Jamie Raskin delivered a warning to the Department of Justice so direct and so sharp that it immediately forced a question many in power seem determined to avoid. How do you justify blacking out an entire document in a case where the law explicitly requires openness and transparency? That was the moment everything changed? Just moments earlier? Members of Congress believed the long-promised Epstein files were finally going to be released to the public. Instead, what they received were pages completely covered in black ink-full sheets where answers were expected, but nothing could be read. It wasn't selective redaction. It was total erasure. And Raskin didn't let that slide. During an interview, Raskin was asked directly whether this amounted to a cover-up. His response was blunt. He pointed to the statute itself, explaining that the law allows redactions only in very limited situations: information related to child sexual abuse, physical harm, active investigations, which the DOJ itself has claimed no longer exist, toward genuine national security concerns. Beyond those categories, he argued, there is no legal basis to conceal information. Blocking out entire documents, he said, simply makes no sense. Raskin then added political context, reminding viewers that Donald Trump opposed the legislation until the very end. Only when it became clear that public pressure was overwhelming did Trump reverse his position and claim support. According to Raskin, what followed was not cooperation but obstruction and effort to undermine the law during its implementation rather than openly defy it. That, he said, is the battle now underway. When asked whether the 30-day deadline for releasing the documents was realistic, Raskin said yes. He noted that back in July, the Department of Justice had already told Congress it had reviewed the materials and found no basis for bringing additional cases. That meant the documents had already been examined. From his perspective, there was no legitimate reason for such extreme delays or blanket redactions. The conversation then turned to a critical issue: protecting victims versus hiding information. Raskin did not hesitate. He said the redactions showed virtually no concern for survivors and instead appeared entirely focused on concealment. In his view, the actions taken showed zero respect for the victims of Epstein's abuse and complete dedication to keeping certain facts from becoming public. Raskin went further, arguing that the secrecy was designed to shield information Donald Trump did not want exposed, whether related to himself, members of his family, associates, Epstein himself, or the broader social, business, and cultural networks Epstein moved within for over a decade. The suppression, he said, wasn't accidental. It was deliberate. When asked directly whether the DOJ's actions were intended to protect Donald Trump, Raskin answered without hesitation. He said that protecting Trump appeared to be the department's operating principle. He framed it as part of a larger effort to reshape constitutional law around the idea that the executive branch exists solely to serve one individual. That concept, known as the unitary executive theory, he argued, places loyalty above law. The discussion also addressed photographs showing former President Bill Clinton with Jeffrey Epstein and Ghislaine Maxwell. Raskin said he did not know the details of those relationships, which is precisely why full transparency is necessary. He emphasized that the goal is not selective exposure, but a complete accounting of the facts for the public. Raskin acknowledged that many prominent figures have appeared in photos with Epstein. He described Epstein as both a serial abuser and a social climber who deliberately ingratiated himself with powerful people across different sectors. Being photographed with Epstein, he said, does not automatically imply criminal behavior. But Congress has made it clear that embarrassment alone is not a valid reason to suppress evidence. He pointed out that figures from across the political and cultural spectrum, including Bill Clinton, Donald Trump, and others have surfaced in Epstein-related contexts. The issue, Raskin stressed, is not partisan blame. The real question is how a global, billion-dollar sex trafficking operation was able to function for decades without being stopped. According to Raskin, that failure exposes something far deeper than individual wrongdoing. It reveals a double system of justice, one for the powerful and connected and another for everyone else. And until that system is confronted honestly, The public will continue to question whether the rule of law is being applied equally. Raskin reminded viewers that Epstein was officially convicted back in 2008, yet that conviction did nothing to stop him from continuing to operate his network for years afterward. The system failed to shut it down, and the abuse continued. He then addressed a common Republican criticism that Democrats should have acted earlier, particularly when Joe Biden was president and Democrats held power. Raskin said that argument doesn't hold up. He explained that he personally can document his efforts going back years. He said he has written multiple letters, held hearings, and used his role as a subcommittee chair on the Oversight Committee to raise alarms specifically about Alex Acosta and what Raskin described as a clear example of a two-tiered justice system in Florida. He pointed out that there was once a massive federal case prepared against Epstein's operation. According to Raskin, prosecutors had a 60-count federal indictment ready to move forward. It included charges related to international sex trafficking, money laundering, conspiracy, prostitution, and more. But that entire case was abandoned. Instead, Acosta negotiated a deal that reduced everything down to a single state-level solicitation charge in Florida, an outcome that benefited Epstein and protected others connected to him. Raskin said that plea deal effectively buried evidence of additional individuals who may have been involved. He added that he has letters proving he demanded hearings on this exact issue back in 2018 and 2019. From his perspective, accusations of hypocrisy are simply a distraction. Calling out someone else does not prove a genuine interest in uncovering the truth. What matters, he said, is finally confronting the crime itself. When asked whether Democrats are planning to sue the Department of Justice to force the release of the remaining files, Raskin said the situation is complicated. He explained that individual members of Congress or even a minority caucus face strict and often hostile court rules when it comes to legal standing. He noted that Speaker Mike Johnson would clearly have standing to sue on behalf of the full House of Representatives. Still, Raskin said Democrats will continue doing everything possible to keep the issue in the public spotlight and apply pressure for transparency. If litigation becomes possible, he said, they will pursue it. For now, legal options are still being evaluated. The conversation then turned to whether impeachment should be considered, specifically impeachment of Attorney General Pam Bondi, as some lawmakers have suggested. Raskin said nothing should be ruled out, but he was realistic about the political math. Republicans currently control both the House and the Senate, he noted. So when people propose impeachments, whether of Bondi, Robert F. Kennedy, Donald Trump, or anyone else, his response is simple: bring Republican votes to the table, and then the discussion can happen. Without that support, Raskin said, impeachment efforts become performative gestures. He referenced what recently happened to Congressman Al Green, whose effort was quickly shut down on the House floor. Raskin emphasized that symbolic votes are not the goal. The goal is releasing the documents and exposing the truth. When the discussion shifted to broader politics, Raskin was asked whether impeachment should be pursued if Democrats retake the House in the upcoming midterm elections, a possibility many analysts say is increasingly likely. Raskin said that right now, Democrats are fully focused on uncovering withheld information and campaigning nationwide. He listed recent campaign stops across the country, including Ohio, Texas, Michigan, and New Jersey, where he has been supporting Democratic candidates. As for impeachment, Raskin said he is not dismissing the idea, but he made clear it is not the centerpiece of the party's message. If people want impeachment, he said, they need to build a serious case, assemble the evidence, and present it clearly. That conversation can happen when the time comes. But Democrats, he stressed, are not running campaigns centered on impeachment. They are running on accountability, transparency, and restoring trust in the system. Raskin said Democrats are running on delivering real results, starting with health care and restoring government as something that serves the common good, not as a tool for private enrichment, not as a mechanism to benefit one individual, their family, or their inner circle. He argued that what Americans are seeing right now is the opposite of that vision. And it's one of the main reasons the president's approval numbers are falling rapidly, according to Raskin. The current administration is unraveling in multiple ways. He said there is no coherent program being offered to the American people, no clear plan that speaks to everyday needs or long-term stability. And that vacuum, he argued, is being felt across the country. He then turned to the Democratic Party's internal reflection following the 2024 election. The Democratic National Committee conducted an internal review and autopsy, as it was described, on what went wrong in that election, which ultimately led to Donald Trump securing a second term. But Raskin noted something unusual. The report explaining those failures has not been released publicly, according to DNC Chair Ken Martin. The party's guiding question is simple. Does something help Democrats win elections? If the answer is no, then it's treated as a distraction. Raskin challenged that logic directly. How, he asked, can learning from mistakes ever be considered a distraction from winning? In his view, refusing to examine errors openly only guarantees they will be repeated. Raskin said he hasn't seen the report himself, but he pointed out that in Washington, reports almost always surface eventually. If leadership doesn't want its conclusions shared, he argued, then perhaps it shouldn't commission such reviews in the first place. Transparency, he suggested, should apply inward as well as outward. He added that politics, like history, is rarely driven by a single cause. Historians call it overdetermined, meaning there are many overlapping factors behind any major outcome. Why someone wins an election, why someone loses, can never be reduced to one explanation. Still, he said, there are obvious factors that everyone already understands. For example, the prolonged uncertainty surrounding Joe Biden and Kamala Harris clearly hurt Democrats. That much, he said, isn't controversial. There may be other reasons as well. Raskin continued, and there's no good reason not to talk about them openly. History itself rarely settles on one definitive explanation. He compared it to debates that still surround events like the French Revolution, arguments historians continue to have centuries later. The point, he said, is not to pretend there's one answer, but to be honest about the discussion. After the interview concluded, the larger meaning of Raskin's remarks became clearer. He wasn't just criticizing redactions. He was accusing the system of something far more serious, turning a law designed to protect survivors into a shield for powerful people who don't want their names, relationships, or past actions exposed. What made the moment so striking wasn't just the accusation itself. It was the certainty with which he delivered it. Raskin didn't hedge. He didn't soften his language. He said the redactions made no logical sense. And more importantly, he argued that the Justice Department's behavior pointed to a single outcome, blocking the truth from reaching the public. As he spoke, it became clear that the stakes went far beyond one set of documents. What was really on the line was the credibility of the justice system itself. Because when the law clearly states that only a narrow category of information may be withheld, yet the government releases pages completely blacked out from top to bottom, a simple but unavoidable question emerges. What are they trying so hard to keep hidden? In this video, we're going to break down exactly why Raskin believes this isn't just bureaucratic sloppiness or excessive caution. In his view, this looks like a structural effort to protect people connected to Epstein rather than the individuals who were harmed by him. And by the time you reach the end, you'll understand why this fight is bigger, darker, and far more consequential than it appears on the surface. The law Congress passed was not vague. It was not open to interpretation. It clearly listed 4 and only 4 categories that could legally be redacted: information involving minors, details related to physical harm, active investigations, and legitimate national security concerns. That's it. Not political embarrassment. Not reputation management. Not avoiding uncomfortable headlines. Just those 4, and that distinction is where everything begins to fall apart. Yet when the documents were finally released, they didn't look carefully reviewed or responsibly edited. They looked wiped clean. Entire pages were erased. Entire conversations disappeared. Whole narratives were gone, not selectively redacted, not partially obscured, but completely blacked out from top to bottom. And that is exactly where Raskin's outrage comes from. Months earlier, The Department of Justice told Congress that everything had already been reviewed. Officials said they had examined the full record and found no legal basis for additional charges. Lawmakers were told the matter was essentially closed. So how does that square with what came next? How can files that were supposedly finished and resolved suddenly require sweeping redactions? How can an investigation declared over now be treated as if it is still active? That contradiction is the fault line. It's the moment where the official explanation stops matching the timeline. And Raskin isn't speculating, he's pointing directly at that inconsistency. If these materials were already processed, already analyzed, and already cleared months ago, then the last-minute blackout doesn't look like caution. It looks deliberate. It looks like an agency deciding that silence is safer than disclosure. That is why Raskin isn't framing this as a clerical mistake or bureaucratic overreach. He's calling it what it appears to be, a potential cover-up of exactly the kind of abuse Congress tried to stop when it passed this law. Then came the statement that immediately grabbed national attention. Raskin openly suggested that the redactions may be about protecting someone with real power, someone with influence over the Justice Department's leadership, someone who has spent years advancing the idea that the entire executive branch exists to serve one person at the top. Raskin refers to this as the unitary executive theory, but stripped down to its core. The idea is simple and dangerous. Government agencies do not serve the public. They serve the individual in charge. And once that framework is applied, those blacked-out pages take on an entirely different meaning, because if the system is structured to shield the powerful, then the key question is no longer why the pages were redacted. The real question becomes who benefits from keeping them hidden. And this issue doesn't stop with one administration. One reason the Epstein files remain so explosive is because Epstein himself was a professional connector. He deliberately embedded himself in elite circles across politics, finance, academia, philanthropy, and entertainment. Photographs exist, showing him alongside figures from both major political parties. Raskin is careful to make one thing clear. Appearing in a photograph with Epstein does not prove criminal behavior. He emphasizes that point repeatedly. But he also makes something else just as clear: embarrassment is not a legal justification for secrecy. Congress explicitly rejected the idea that documents can be withheld simply because they contain uncomfortable, awkward, or reputation-damaging information. The public has a right to understand how someone with Epstein's known history was able to move freely through centers of power and avoid real accountability for decades. The photos circulating online are not the core issue. They are symptoms. They show how wide Epstein cast his net. What matters now is not who posed for a picture at a party. What matters is who enabled him, who protected him, and who benefited from his ability to operate in the shadows for so long. And that leads to the deeper failure, one that began years before the current confrontation. Epstein didn't simply fall through the cracks. The cracks were widened for him. Raskin has been warning about this long before these latest disclosures. He held hearings on the infamous 2008 plea deal, a deal that should have triggered national outrage. At the time, federal prosecutors had indictments prepared. Dozens of charges were ready to move forward, and that is where the story truly begins to unravel. Somehow, that case was hollowed out. Serious charges were stripped away. The potential consequences were reduced to something shockingly small compared to the scale of the crimes involved. That plea deal didn't just shield Epstein himself. It protected everyone connected to him: the money, the network, the enablers, the facilitators, and anyone who might have been exposed by a full investigation. And according to Raskin, that moment created a blueprint for what we're witnessing now. What he sees is a system that consistently bends for the powerful while leaving survivors to carry the burden alone. Time and again, it's the survivors who have pushed this process forward. They are the reason investigations were reopened. They are the reason lawmakers felt pressure to act. They are the reason new legislation was passed in the first place. Without them, this story would have faded long ago. So when survivors see these document releases pages completely blacked out, they don't interpret it as responsible caution. They recognize the pattern. To them, it looks like history repeating itself. A system that shields institutions and influential people, while those who suffered the most are once again pushed to the margins. This isn't theoretical for them. It's deeply personal. Every delay, every erased page, every unexplained inconsistency sends the same message. Powerful people still receive special treatment. Transparency is optional. Accountability depends on status. And justice is negotiable. Raskin also points to another layer most people outside government rarely consider: legal standing. Individual members of Congress often do not have the authority to sue federal agencies to force the release of documents. Courts frequently rule that they lack standing. That power usually rests with House leadership. And if leadership chooses not to confront the Department of Justice, whether for political, strategic, or institutional reasons, then the law can effectively be ignored. That's why Raskin is clear that this fight doesn't end with one document release. It doesn't end with a single hearing. And it certainly doesn't end with a stack of heavily redacted pages. The struggle continues because the system itself is built with barriers that protect agencies from real oversight, unless there is unified political will to challenge them. And right now, that will is fractured. So where does that leave us? Right in the middle of a fundamental battle over what transparency actually means. Not as a slogan, not as a talking point, but as a legal obligation with real consequences. Because if government agencies can choose which laws to follow and which to sidestep, public trust collapses. It becomes impossible to believe future investigations will be handled honestly. It becomes impossible to tell whether the truth is being revealed or carefully managed. That is the core of Raskin's message. This isn't about party politics. It isn't about revenge or settling old scores. It's about whether the law applies equally even when it's uncomfortable. Even when powerful people would rather it didn't, even when the truth might embarrass, disrupt, or expose a system that has failed again and again. Right now, the redactions raise far more questions than they answer. And until those pages are released in full without walls of black ink, the public will continue to wonder what's missing and why. History shows that truth, in cases like this, rarely emerges all at once. It comes out because people refuse to accept silence, because survivors keep demanding answers, because lawmakers like Raskin refuse to let the issue disappear. If you want more deep, fact-based breakdowns like this, more coverage that cuts through spin and explains what's really happening behind the scenes, make sure to subscribe. Hit the like button and turn on notifications so you don't miss the next video. The more people understand not just what's been released, but what's still being hidden, the harder it becomes for the truth to stay buried.